Hey friends, I'm back with another video. Today I am gonna discuss about Article 13 of the Indian Constitution. In the previous video, I talked about Article 12 which defines state, and I also explained precisely the significance of state with regard to the chapter 3rd of the Indian Constitution. You see, I said there that there are five fundamental rights. Although I explained six, but it was wrong of me. There are six fundamental rights. So today, it's Article 13 of the Indian Constitution. Generally, Article 13 uh, talks about those laws which are inconsistent with the fundamental rights, and those laws which violates fundamental rights or void, right? Article 13 contains three clauses: clause 1, clause 2, and clause 3. Clause 1, it says that it declares rather that all those laws which were in force in the territory of the India before the commencement of the constitution shall be void to the extent to which they are inconsistent with the provisions of the part 3rd of the Indian Constitution. This is the first clause of the Article 13, and the second clause is that it the second clause puts a bar. It prohibits the state to frame any law which which is inconsistent, which abridges any fundamental right of any citizen, right? And the third clause of the article is that it says that it rather gives a broader connotation to law. It includes any law. It includes ordinances, order, bylaws, rule, regulations, notifications, customs, etc., and having the force of law. Thus, we can say that anything which is having the force of law and is and violates the nature of the fundamental rights can be declared as void, right? You see, uh, today I'm only gonna discuss about clause 1 and several doctrines. um, Clause 1 of the article, it basically relates to the it pre-constitutional laws. As I said that before the commencement of the constitution, there there were the laws which were inconsistent with the when which became rather inconsistent when the constitution came into being. And as you all know, our constitution came into existence on 26th January 1950. and and those laws which became inconsistent shall be wide to that extent. Now the question here is Article 13 a prospective or retrospective in effect? The answer is that Article 13 is prospective in effect. It's no retrospective in effect, right? And you see, there is a doctrine, as I said, doctrine of severability. The question arises when a parliament or a legislature frames any law, when the one part of that law, that statute, is offending, is violating the fundamental rights. The question arises whether that specific offending part can be declared as null and void, or whole part can be declared as null and void. And this controversy, this confusion was set at rest by the Supreme Court, and it devised the doctrine of severability. It said that only the specific offending part can be declared as void. See, uh, there are a bunch of case laws to understand this concept. I'm only I'm today I'm gonna only to you see I will pick only one case law here to make you understand this concept. RMDC versus Union of India is a case law where a price comparison act was challenged, and there were in this act there were two things: one, competition of gambling nature, as well as competition involving skill. When the act was challenged before the court struck down the second part, that is that is sorry, first part, competition is of gambling nature. This part was struck down, and the remaining part was retained by the court. Thus we can say that if any part is offending, that very specific part can be struck down by the court, and the remaining can be retained. But one thing is to be retained in mind, one thing is to be borne in mind, that if the if that offending part, when struck down, the remaining part cannot survive without the offending part, then the whole part is to be struck down. Meaning, in simple words, if there is a statue, right, and the court struck down its offending part, and the remaining part cannot survive without this part, and that the court has to struck down the whole part, the whole statue rather, right. And there is another doctrine, that is doctrine of eclipse. This doctrine is based on the principle that a law which violates the fundamental right is no nullity or void ab initio. It's very simple to understand. It's based on that principle, that a law which violates fundamental right, it means any law which violates fundamental right cannot be declared void ab initio. That law becomes only an enforceable, that is it remains in the moribund condition, it is overshadowed, right. And the very fascinating question arises here, that is, can such a law which becomes unenforceable after the constitution came into force be revived? Can it be revived by the subsequent amendment, and if rather an effective amendment? Yes, it can be. This thing was solved by the court in the Bikhaji versus State of MP. Actually, there was an act which authorized the state to monopolize any business. That act authorized the state government to make up the entire motor transport business in that province to the and it excluded the motor transport operators. And meanwhile, the constitution came into being in 1950. Article 19(1) clause G, it directly came into the contradiction of this Article 19(1) clause G, and the act was challenged on this basis, and the government immediately amended clause 6 of the clause 19, sorry, Article 19. So the effect of the amendment was to remove the shadow. The shadow was removed. The shadow was removed by this amendment, right? So, in simple words, the shadow can be removed by an effective amendment. So there are the bundle of cases are there. There are the bunch of instances you can see, and The second clause, which is related to the post-constitutional law and the various doctrines, and the third clause, uh, the second clause and various doctrine is related to it, and the third clause I'm gonna discuss them in the coming video. And I hope today's video is interesting for you people, and if you like it, please give it a thumbnail and don't forget to subscribe this channel. Thank you so much.